Okay. All I'll point out is there's a chapter on material. Do you use the word material in your contracts? Material breach, and so on. My only point is, well, there's an entire chapter, but the main point regarding material is that it's vague. It depends on the circumstances, but also it's ambiguous because courts use material to mean a really big, something that's important, a deal breaker change.
Relevant.
Yes, it has to be, but it's really important. But drafters also use it to mean just important enough for me to pay attention to it. So the result is you can have a phrase like material breach that is used in two places in a contract. It's used in a statement of fact where the meaning seems to be, Widgetco, we don't care about your trivial breaches. But in a termination provision, it seems to say, Widgetco, you're not terminating unless it's a deal breaker breach. So two places, one phrase, seemingly two different meanings. So watch out for material. Ask yourself what meaning you're trying to convey. This is one place in the introduction to, well, the preface. I think the preface to the 4th edition. I said I tried to think where I changed a recommendation from the 3rd edition to the 4th edition. I could think of only one thing. The 3rd edition suggests using defined terms for the two possible meanings of material. That's not what I do anymore. What I do, or if I'm not sure I ever did it, what I do now is way simpler. Courts say material is deal breaker importance, so I use material for that meaning. If I mean the other end of the scale for importance, I use non-trivial. So just important enough that it isn't trivial. So those are the two words I use. Material for deal breaker, non-trivial if it's, hey, just important enough for us to pay attention to it.
Did I include the definition for that?
The book, particularly the 4th edition, says, hey, you don't have to, but if it's useful, here is a definition. And it's the same as the definition that's in the 3rd edition. Selected usages. Okay. This is basically any word or phrase that didn't fit elsewhere. In the 1st edition, the selected usages chapter was 60 paragraphs. In the 3rd edition, it's about 770 paragraphs. In the 4th edition, it's about 940 paragraphs. So it's grown because I just keep finding new different things to write about. Here are some of my favorite selected usages. In fact, efforts is such a favorite that it has a chapter by itself. Do you deal with efforts in your contracts?
Yeah.
Or endeavors if you're doing the English thing?
Yeah.
Yes? Okay. I had, let's see. I prepared this in May, because originally I was going to be here a few months ago. Immediately after, I became involved unexpectedly in reassessing this. Let me just start the discussion by observing that I did this analysis way back in 2004, looking at a bunch of contracts and looking for 1 month on a database and looking at all the different efforts provisions. That raises the basic question, and obviously the English talk about endeavors, everyone else talks about efforts. I'll use efforts now, but raises the question, what's the difference between best efforts and reasonable efforts? Does anyone have any suggestion?
Reasonable is less than best, but it's also acceptable.
It's also reasonable, I guess. I guess the way I hear people express it is reasonable efforts is what's reasonable. Best is Best is doing everything in your power. Yes, you have to do everything you can to comply with the obligation, even if it's to your detriment, even if you have to drive your company off the cliff in the process. But a funny thing happens once you start looking. So I'll introduce this by explaining how a few months ago, the Chief Justice of the Delaware Supreme Court. Delaware is an important state for corporations, and I've exchanged emails with the Chief Justice. In a dissent, in other words, the courts had decided one way, and the Chief Justice said, "I don't agree," and in his so it doesn't have force of law. In his dissent, he said, just in passing, he said, and by the way, of course, different efforts provisions have different levels of obligation. You have to try more or less hard depending on the efforts provision. And I said, what? So I leapt into action because basically all U.S. courts have said all efforts provisions mean the same thing, reasonable efforts. And that makes sense in ways I'll explain at the moment. So I had to leap into action, and I felt a little awkward. I had to do a blog post, and the Chief Justice is going to note that he's now in the 4th edition saying the Chief Justice said something really bad, which is just there's no basis for his saying that in U.S. case law or in terms of the English language. But I'm happy he said it because that caused me to do some more research, and it's really the first real research on the subject. I looked at the original phrase in English was from the 16th century, to do one's endeavors. He did his endeavors. That's the original. And then some people would say he did his best endeavors. And the Oxford English Dictionary definition of to do one's endeavors includes some examples of best, like from Shakespeare. But it puts them all together. It says there's no different meaning. That's because in English, the word best is often used just to show I care. It's in your best interest. That means the same thing as it's in your interest. It's a way of showing, hey, I care, or I know you care. It doesn't change meaning. Then I looked at Google Ngrams, useful tool. Google has digitized millions of books. You can plug in a word and see how it's been used over 200 years. So I looked at 200 years of how best endeavors and reasonable endeavors were used over the course of 200 years. And what we see is that best endeavors, it's used a lot. The main point is that reasonable endeavors doesn't exist, basically, until recently. It's a legal invention. So I explain this at greater length on my blog and in the book, but the basic idea is the idea that best endeavors is super efforts and reasonable endeavors is normal, reasonable stuff. The way these phrases are used shows that that doesn't exist, because reasonable endeavors no one uses until only a few legal people recently have used it. So it's an invention. So the distinction doesn't exist. So U.S. case law says all efforts provisions mean the same thing, reasonable efforts. English case law is a disgrace because English courts make stuff up. They do things like say that all reasonable endeavors is a stricter standard than reasonable endeavors. And I say, what planet are you from where you can say that? There's no basis in how people write or speak for that. English courts make stuff up. It's a problem. and I make it my business to say this to judges' faces. I regard it my responsibility to be in people's faces about this stuff. I'm sure they love hearing it.
How about necessary efforts?
No, I've put together we don't have the chart here on my blog. I put together a chart of all the different variations. They're also, I say it's mix and match, because there are different elements you can throw in. There's a little chart. Just search for efforts on my blog and you'll find it, a little chart showing all the different things you can put in. The bottom line, this is a long story, but here's the idea. I recommend strongly you forget that best efforts, best endeavors ever existed, because it doesn't make sense. Because, just as I showed that my research has showed that the distinction doesn't exist, that's because it doesn't make sense. Because if you tell someone, okay, you're under a best efforts obligation, you might have to act more than reasonably in complying with that obligation. Well, the only thing left after reasonable is unreasonable. You're in effect telling the other side, you might have to act unreasonably. And they're entitled to say, exactly how unreasonably do I have to act? It doesn't make sense as a matter of how people speak and as a matter of contract law. The idea of imposing an obligation to act unreasonably doesn't work. So, first, efforts. Reasonable efforts is a vague standard. You use it when someone doesn't have control. Acme shall obtain the government permits. Well, it doesn't really make sense someone has an obligation to obtain permits, because they're not in the business of issuing permits to themselves. The government agency issues the permits. So it's reasonable to say, okay, it's fair to say, shall use reasonable efforts. But you want to limit vagueness wherever possible. You only want to use it when you really have to. So I recommend you not say best efforts. If someone insists on best efforts, depending on the jurisdiction, in the U.S. you'd say the courts say what you ask for doesn't exist, and we know it doesn't exist. In England, I'd say what you're asking for doesn't exist. Courts have tried and failed to come up with a distinction, so you're just asking for confusion. So what do you really want? What more than reasonable do you want? Let's try and find a way of expressing it.
Beyond reasonable.
Yeah, well, just something, if reasonable isn't good enough, then you have to be able to express what you're looking for.
Can't you express it in a way? Can we say that reasonable is more an objective?
No, nice try. But once you try the business of, one is objective, the other is subjective, if you devote a minute and a half to trying to think that through, you'll see it doesn't work. So there's always a way. If reasonable isn't good enough for you, then you have to be specific about what you're looking for.
You see, from my experience, I've always been taught, or I was taught this, that when it was reasonable, you're assuming that you're doing positive. Actually, if you're a company, you're doing positive actions as a company. Best endeavors, what you're doing effectively is you're expending it, even if you have to include other third parties.
Oh, sorry, we're the
Other third parties in assisting you.
Okay, here I'll summarize just the idea that reasonable. I've already forgotten what you're saying.
An example would be reasonable endeavors. So if you're doing your permit example, for example, so you'll obtain a government permit. You'll use reasonable endeavors to obtain a government permit, which means you'll use your own company personnel. Best endeavors, you'll use other third parties, so you expand money.
The answer is that might be what you think, but there is zero accepted evidence. There is zero evidence anywhere to that effect. I've not seen there. I've looked at loads of case law. There's nothing, no case law suggesting that. And furthermore, I don't want to do contracts in riddles. I don't want to use mystery phrases with some sort of hidden meaning. So it doesn't. If that distinction is what you're aiming for, it's one you can express quite clearly. So just. If you use reasonable only when you use reasonable efforts only when you can't be more specific. And if you want more than reasonable efforts, you're just going to have to tell the other side you're going to have to be specific. There are ways of limiting limiting the vagueness. For example, Acme shall use reasonable efforts to obtain the government permit, but you can say Acme shall apply for the permit no later than 9 July. In other words, you can identify elements of the task where you don't need to be vague because Acme has control. Furthermore, reasonable efforts by itself can create problems. I wrote recently about two New York court cases. One court said, reasonable efforts? You have to do everything. What people think of suggested best efforts means. The court said, you have to do everything, and if you don't like it, talk to the bankruptcy court. Another New York court said, you can balance your other priorities. Two very different interpretations, two courts from one jurisdiction. So how do you handle that? I suggest that you consider using carve-outs as a way of eliminating the possibility of extreme interpretations. Acme shall use reasonable efforts, except Acme will not be required to retain consultants, to spend more than X dollars, whatever makes sense. Carve-outs. So, and don't use multiple efforts provisions in one contract. That's just asking for trouble, for confusion. Usually, it's not a result of choice. It's a matter of copy and paste-itis. The disease of copying and pasting, where people are just copying from all over and they don't go through and make it all consistent. A few weeks ago, did an in-house seminar, and I told the host company, the company gave me some of their templates to take examples from. I said, congratulations, your template has 10 different ways of expressing efforts provisions. There should just be one.
Excuse me.
Yes.
Is it a good way to define reasonable effort by what any reasonable person would? I'm not sure, but some of the main U.S. cases have defined such an act with regard to what a reasonable person would expect something.
Well, yeah, basically, there's this defined term, and there's some discussion of it in the book. It's rare that I use it because it's still going to be vague. You can't escape vagueness. Some lawyers think you can avoid vagueness by throwing a lot of vague words at it. No, it's always going to be vague. So there might be contexts where you can use it you can define it, and that way you can refer to practice in a particular industry or something like that. But it's always going to be vague, so I don't do it very often. And reasonable is just going to be, hey, it's reasonable. And courts might express it in different ways, but it all boils down to, hey, what do we think is reasonable? And there's no magic to that. It's just the court is going to stick its finger in the air and say, is going to try its best to say what is reasonable. So, are you okay with the idea of not using best efforts? You might find some people arguing with you, but I think it's clear what makes sense.
Okay.
Yeah.
I have another question regarding the norms and customs.
Okay. Perhaps speak in the microphone. Just make.
Regarding the norms and customs, when referring to such an act to be done in accordance with the norms.
Okay. Okay. Oh, okay, sure. That's a separate question in terms of practices in a particular industry. That's not necessarily efforts.
As an alternative to reasonable effort.
Well, it's different. You can say someone has a flat obligation. Acme shall build the bridge or shall perform the tests. And then you say what the standard is. It can be specifications, or you can say practice in the industry. You can use workmanlike. You can search on my blog for the word workmanlike, where I talk about this sort of thing, and it'll be in the 4th edition. So there are different. You can use different ways to say what the standard is. My preferred thing is if you can give specifications. That's the best. This is how we want you to conduct the tests, rather than saying, do whatever people in the industry do.
I mean, sometimes it's hard to get a specification.
Oh, I know, of course.
In industry, you will get a specification.
No argument. No argument. So I'm just saying, what is, the more specific you are, the less trouble you're going to get into. But I know you can't always be specific. So, all right. Let's see. Are you indemnify and hold harmless people? Indemnify and hold harmless? Raise your hands if that's in your in contracts you looked at. Indemnify and hold harmless? Only a couple. Well, all right, just a few of you. Well, because hold harmless does not have an accepted meaning. This is a great example of redundancy. It's like once upon a time someone said, indemnify, hold harmless, which do I use? I don't know, I use both. And now they say, oh, that makes me look smart. And then once you have redundancy in a contract, people start trying to invent explanations for it. Oh, indemnify means this and hold harmless means that. And I say, no one agrees to that. You can invent all the reasons you want. They're called, apocryphal. How's that, interpreter? That it means they're invented after the fact. Someone tries to come up with some explanation to make themselves feel better about traditional contract language. Oh, it's not that chaotic. No, it is chaotic. The problem is that since hold harmless doesn't have an accepted meaning, people get into fights over what it means, with the result that you can find litigation all over the place over indemnify and hold harmless. You're just asking for trouble. Your job as drafters and reviewers is to stay out of fights. It's not to use mystery phrases to express meaning. I get rid of hold harmless, use indemnify, which is a term of art. It's a fancy word. It's a dollar word used to convey 5 cents of meaning. But it has a set meaning, so we're okay with it. But it isn't where the action is. Acme shall indemnify Widgetco against what? The what part is the important part. Are we talking about reimbursing out-of-pocket losses? Are you talking about assuming liabilities? Is it just non-party claims? Or is it claims between the parties as well? Just say what the deal is. That's your job, not to use mystery phrases. And incidentally, yes, indemnify is a fancy word, but there's always a simpler alternative to terms of art. If someone doesn't like indemnify, instead of Acme shall indemnify Widgetco against, how about Acme will be liable to Widgetco for? That's a simpler way of saying the same thing, if someone doesn't like indemnify. And defend, indemnify, defend, and hold harmless. What is the word defend meant to address? All the procedures that take place in handling indemnification claims? One word isn't going to do it. On my blog, there's an indemnification category. And a few items down, there's something called My Indemnification Language. I thought I was being a real humanitarian when a couple of years ago I said, here, world, is my indemnification language. My readers then beat me up for weaknesses in my indemnification language, so I crawled away and fixed it, and I go back occasionally and I make adjustments. I think it's a pretty good starting point for an indemnification provision in a commercial context, and it has provisions dealing with how do we handle indemnification claims that actually address the issue instead of just defend. That's indemnification. Any questions, objections? You're okay, so we're in agreement. You're never using hold harmless ever again. I'm glad we had this conversation. All right now. Represents and warrants. Raise your hands if that is in your contracts. Anyone with represents and warrants? Just a couple of you? Oh, all right. 4 of you. I'm a little disappointed because represents and warrants used to be my biggest enemy, but now I've defeated it. So it's back to efforts again. No, represents and warrants. Well, it's used traditionally to say here are some facts. Acme represents and warrants that the equipment is in good condition. I ask myself, why represents and warrants? What? And it's just it's a complicated story. All these stories are complicated. I ended up writing about it in a 2015 article that just, I've been writing about it for years, but finally I said, I've had enough. So the article is sort of, it's over. Because I looked at the two suggested functions for represents and warrants, and they all made no sense. Right, it's just represents and warrants is pointless and confusing. In fact, it's so pointless and confusing that it's just plain old dumb. But it's used everywhere in the U.S. Of course, but interestingly, U.S. courts pay no attention. U.S. courts are very sensible. 93% of people who work with contracts think there's a distinction between best and reasonable efforts. 98% of people who work with contracts think that they have to say represents and warrants. U.S. contracts have said, U.S. courts have said, we don't care what verb you use to introduce statements of fact. So I'm not going to get into the explanation of this stuff, since not enough of you see represents and warrants. Instead, I'm just going to tell you what I do. You want some facts? I say Acme states that the equipment is in good condition. Because the traditional people like to say, oh, which verb you use to introduce statements of fact can, for example, affect remedies. You know, whether you can bring an action for misrepresentation or an action for breach of warranty depends on whether you use represents or warrants or both. And amazingly, U.S. courts have said, we don't care. English courts, the land of crazy contract interpretation, some English courts have said, oh, it affects remedies. Other English courts have said, no, it doesn't. So it's just confused in England. But so I've elected that I'm just not, I'm going to use the simplest possible word. So I'm just saying, here are some facts. And if the facts are inaccurate, then you'll have whatever remedies the law provides. Unless you care about remedies, if you care about remedies, then we can talk about remedies however much you want. You can create a section called remedies, called indemnification, called liquidated damages. Do whatever you want. But in a commercial context, most people aren't interested in trying to guess what kind of disputes are going to come up and provide for remedies. In mergers and acquisitions, sure. Maybe in lending, maybe. If you want to, you can do it. But otherwise, it'll be what law provides. So that's what I do. And my consulting clients for commercial contracts say, Fine. If you're doing a contract 400 times a year, you want to make the deal cycle faster. You want to get rid of nonsense. Big law, big M&A deals, it's going to be a long time before they get rid of represents and warrants, because clients don't care about efficiency. Clients don't care about clarity. They're betting the company. They're just saying, big law firm, do whatever you do and just have the outcome be good. So big law firms aren't going to change. But for commercial clients, this is what I recommend. Anyone, any comments or anything thus far?
I have a comment on this one.
Okay.
I think, I'll excuse my fellow lawyers, sometimes law firms tend to include a lot of terms and conditions in the contract to make it as a justification as why they costing more
fee?
to the client. So it's like buying a kilo of tomatoes and they said, oh look, 60 pages contract. Of course,
Yeah, I know. Well,
10 pages.
I see people suggest different explanations for the nature of law firm contracts. One is that it's a conspiracy that to confuse us, and I say the simplest explanation is that everyone is confused. I see nothing to say that lawyers are the exactly. There's we are the have this plot that we know better. No, it's everyone is confused. The lawyers are the ones who are copying and pasting like crazy. They don't know what's going on. It's not, the lawyers should draft contracts to make them clearer for us non-lawyers. No, everyone needs help. And in terms of to bill more, well, certainly there's no incentive to efficiency. But mostly I don't think they're saying, all right, let's just crank this up. I think it's just a lawyer urge that isn't the clients are not good at constraining. Clients aren't good at telling law firms, I'm looking forward to the first time a consulting client says, law firms, please send your lawyers to Adams's seminars and please buy his books and give us his kind of contracts. That hasn't happened in a systematic way yet. But mostly I think it's just the copy and paste disease that does this, rather than they're trying to take advantage of clients.
But that ignores, certainly from an English law perspective, it ignores years of case law. So you've admitted.
What does?
So for example, yes. So you have a breach. So a breach of warranty would entitle you to a certain form of
I'm going to cut
redress.
you off if you don't mind, because I've considered the English case law. I know what I speak of, and it's a little complicated. But my article deals with it in detail. Deals with English case law in detail, and it's mixed. It's messy. And believe it, the English case law cited for represents and warrants and cited for endeavors is not some English case law stretching back centuries. It's from the last 25 years or something.
Sure. But
no,
if you have a case that favors that judgment, then as a lawyer you have to take that into consideration. You can't ignore it, because under common law, case precedent applies.
No, actually, excuse me. What you have is confused case law. If there is a context where a court says, to get this outcome, you have to do this, then I say, hey, I think doing that makes no sense, but the court says I have to do it, so I recommend that we do it. Represents and warrants is not that context, because first, the case law is confusing, and second, I'm not in the interests of, I'm not in the business of winning fights. So just because a court said, here's a fight, and we find that Acme wins this fight because Acme said whatever, I'm not going to say, oh, I'm going to do what Acme says, because instead I have a way that I don't have to get into the boxing ring at all. I don't have to replay old battles. Instead, I'm going to say, no thanks, I'm out of the game, because I'm going to, instead of dealing with a bunch of confusing case law, I'm just going to say something completely different that avoids the battle.
You start a whole new battle of the word states.
Well,
if that goes to court, becomes ambiguous.
No, because the thing is, you ultimately have to have confidence in the English language. I have confidence in the English language. There's one example that of my approach that did come before a court. The Delaware, it was the fellow who's now Chief Justice of the Delaware Supreme Court was before in the Delaware Chancery Court, which is the leading business law court in the U.S. He was talking about the concept of survival of provisions after termination. And he said, he was talking about the language used in the contract, and he said in a long footnote, he didn't have to, he's a guy who likes just kind of saying things on the side. He said, and by the way, Adams, in his book, says the traditional language is a mess, and you shouldn't use it. And we can applaud that approach, but we have the traditional language in front of us, so that's what we have to deal with, and that's exactly what
So what about
that's the summary of it. That's basically it. He's saying Adam's language isn't in front of us. So ultimately, I'm not going to. You're either a slave to the messy precedent, or you're going to say, I'm going to say what I want to say clearly in a way that I'm confident in my ability to say stuff clearly, and I'm not going to be a slave to refighting wasteful battles and relying on confusing language just because the court said, in this case, the confusing language won or something. So
sure, but commercial contracts by a majority, certainly in this region, are governed by English law, and English law precedent makes a huge difference in terms of how contracts are interpreted.
That's fine.
So if you're going to introduce new terms into an English law governed contract, then it's going to be challenged. So what in effect you're suggesting is you'll have a whole chain of new case law to argue about states.
I reject that.
Yeah, but
it is. If you're saying I can't speak for English courts have a tendency to invent stuff like their analysis of efforts and endeavors and represents and warrants, but it's using the confusing mystery phrases that what leads to the fight. So,
but the solution is not introducing new mystery phrases.
I'm not.
States becomes you're giving it such an importance that it becomes a new term.
No, and in fact, I recommend in the book, the 4th edition, and in my article, that you can add a sentence saying the verb used to introduce statements of fact doesn't have any effect on remedies, for example. So you're just making clear that all we're doing is here's some facts, and if you care about remedies, then address remedies. You ask the other side, do you care about remedies? If you care about remedies, please tell us now. So if you don't, the classic English thing is, well, we don't.
But the whole point of a contract is to.
I think we have more ground to cover. So thank you. Notwithstanding, are you notwithstanding, people? So I'm at Acme's offices. I'm about to sign an employment agreement. It says signing bonus. That's great. I signed the contract. I sort of, I'm so overjoyed at the possibility of the signing bonus. I don't pay attention to the rest of the contract. I sign it. I say, "Where's my money?" The general counsel says, "Didn't you read section 3?" What, Section 3? Notwithstanding Section 1, Acme is not required to pay if last name begins with letter A. No signing bonus. I'm outraged. I storm out of the conference room, slam the door, call my lawyer. It all ends unhappily. Then in an alternative universe, I read a different version of the contract. Subject to Section 3, signing bonus. Well, that sounds good, but I guess I better read Section 3. Not required to pay. Last name begins with letter A. Well, hey, no signing bonus, but hey, they're a good company anyway. At least I learned before I signed the contract. So I signed the contract, things end more happily. The moral of the story is that notwithstanding is used as a way to undercut some other provision in a contract. You can read any provision in a contract, there might be a notwithstanding somewhere else that says things are not what they seem. A more reader-friendly thing to do is to use subject to in the provision that is being undercut. So you tell the reader, you got to read something else. And the least helpful form of notwithstanding is notwithstanding any provision of this agreement to the contrary, which you sort of use when it's 3 a.m., you've added something new to the contract, you have no idea how it affects the rest of the contract, so you throw this in, and it says, in effect, hey reader, this provision might or might not affect one or more other provisions in this contract. Good luck figuring it out. So it's an aggressively anti-reader thing to say. Including. Let me think. All right, let's hold on for a second. We'll consider including after the break. Now, I didn't mean to cut you off too much, but we can spend a long time talking about that. But basically, it's a matter of. Well, I'm not in the business of saying, let's make things clear just because it's the classy thing to do and I'm willing to tolerate the additional risk. In what I do, clarity and avoiding risk are just the same thing. The whole point is to avoid risk. So if I recommend something novel, and states is novel as can be, and it's to be used carefully. Right? It's because a lot of people are just not going to be in a position to accept it. If I recommend something, it's because I think I have eliminated any basis for confusion. It's novel, yes, it's novel, but it isn't confusing. So, and I suggest strategies to make sure that's the case. So, something like represents and warrants is just it's pointless and confusing to the point of being stupid. And I've written at length about it, and it is it's amazing how just the way people use things constantly just because they don't have the time to do what I've done. I'm the one crazy guy who said, hey, I'm going to spend my life buried in this stuff and figuring out what it means. I happen to find it fascinating. Most people just don't have the time or the kind of brain that it takes to do this. So I have on the one hand, stuff that makes no sense. On the other hand, stuff that is new, but that I have kind of tested it, not by creating lawsuits, but just by looking at it from every different way and seeing how I can eliminate any risk. I make sure that my suggestion does not contain risk, and if there extra moves to make to reduce any risk even further, then fine. It's all a matter of balancing that contracts involve risk. There are no contracts without risk. If you don't want risk, don't do contracts. So it's a matter of acceptable risks. There's no certainty. And if I recommend something, it's because I feel that in reasonable contexts, it stands the best chance of making things clear. And it is break time. And we will resume at 4 o'clock for the final push. So see you in half an hour. Again, so, excuse me.
No,
sir.
I understand. It's just, you see, from my perspective, you're taught at law school, working through practice. I mean, one of the key differences between risk representation and breach of
I know. Well, you're talking about terms of art.
Yeah.
There's a big distinction between terms of art, terms of jurisprudence. The fact that
the remedy is the issue.
yeah.
So you have remedies in tort and remedies in contract.
Do you think you're telling me something?
Like, thank you for coming, and this is part of the program. Okay.
We're going to make this also fully sensitive.
Oh, yeah, so, I'll have my, I'll just do it ad hoc without my slides.
Thank you, CLDP, Department of State Funding, SCCA.
I would say something like, this is an effort, so that I'm sure you know, I always think about this big picture is we're trying to improve the which is, and it's time is really important because with the commerce going well, a lot of the others, yes. I gave this tear-jerking presentation for like my third year. It was like, we're all Moroccans, we're hugging and stuff. You should try it. You want to do it? Come on. You're not going to learn this presentation. Why not? You can't do it. I'll tell Mark was great.
Honestly, next time I'd be happy to do it.
Okay, next time you do it. Yeah, sure. And because we talked about that before, like
Yeah, we did.
you giving part of the presentation. What was it?
Presentation. Happy to give remarks. Anyways, I'm gonna go wait for Felipe, assuming he's showing up now. The officer. The officer from him. I'm just gonna step out. Because you guys are gonna start again?
Yeah.
What do you want?
Take a
Picture of you.
yeah, if there's any.
We're gonna get all the pictures that you take.
Okay.
Yeah, you can show. Just do it anyway. Stand up there as you're doing the presentation.
Okay.
Hang on, you gotta come in a little bit. Do the. All right, now.
But act is, well, no, act is.
You turn it up. So do me a favor, and you want to be about this much. So as if you're talking to those guys.
But then it looks like I'm just doing a fake sort of presentation appearance.
Exactly.
So okay.
My problem is they're all like if you focus on that one.
That's
But I'll get all the pictures and I sent you pictures from last time. There was a few where it was a good shot of you and then the rest.
Yeah, and I think, the guy did come around with canvas, so that ought to do it.
You are so lucky you work for yourself. You should really appreciate that. I don't care how much.
I do.
I hate collaborating with people. That's my new thing.
Yeah, I'm perhaps
I just want to do it my way and forget about it.
I can't say I'm all that great either.
So I mean, why can't you just do the legal Zoom alternative as a competitor and see if you can get some?
That's I'm not. LegalZoom is such a bottom feeder that's not.
They're really bad.
Yeah, I mean, it's, so I'm just. I'll see what I can do. Okay. This is the big final push, and now the session before the break was perhaps a useful one because Faisal served as an excellent spokesperson for the traditional approach. and you might have gotten a sense that I wouldn't have gotten very far if I weren't a bit of a fighter, because if I would just say, oh, okay, I just wouldn't have survived. So instead, I tend to get a little. I feel like I'm in the boxing ring with this stuff. So it's just it's not particularly healthy, and sometimes on my blog you can see the fireworks. So it's a little silly, but I wouldn't have lasted if I didn't care about this. It's pretty a pathetic thing to care about, but I care about
You
it.
think we could say that it's a jihad of sorts? Is that appropriate?
Yeah, well, hey, there's a lot of.
It is. It's a struggle.
Yes.
And it's,
Of course, given the American unhelpful understanding of this terminology,
that's why I asked you.
I would not. If I
We won't put it on the blog.
if I were on the
Well, especially in this day.
on the stage, I know. It's
God,
rather
you're right.
it's rather sad. So anyway, including. So hey, what the heck? Are you including? Who uses including without limitation, including but not limited to? Do you I assume everyone who works with contracts regularly uses including but not limited to and so on. Well, yeah. The thing is, I have been using just including for the last 15 years, and I am at peace with it. I'll explain why. When you include examples like this, fruit including oranges, lemons, and grapefruit, you put pressure on the class. A court looks at that, they can say, well, fruit means citrus fruit. Because the more examples you include, the more someone can say, oh, you're only talking about things that are like the examples. So drafters say, when a court says fruit means citrus fruit, drafters say, well, we wanted fruit to include apples and peaches and watermelon. How do we fix that? I know. Let's say we say without limitation or but not limited to. Mission accomplished. But not really. Because for one thing, there are courts that look at but not limited to and say, we don't care. Fruit means citrus fruits. As is often the case, there's a bigger issue here. It's a question of how you use including. I use including, but I don't use it in this way. I'll put an X. I don't use it this way because I don't want to include a bunch of obvious examples. We know they're all fruit, so why would I list them? Instead, I use including in this way. Fruit including tomatoes. I use including to bring within the scope of the class in question, fruit. I use including to bring within the scope of the class in question something that is on the gray edges. You could have a thrilling discussion about whether fruit are tomatoes or vegetables, depending on whether you're a gardener or a cook. I don't want to have that kind of tomato fight in my contract, so I'm going to say fruit including tomatoes. So I go out to the gray edges, and because it's surgical, it's targeted. Like that, I'm not going to get, no court is going to say fruit means tomatoes. I don't get into trouble with this use of including. So that is why I just use including. And it's easy to see why including but not limited to gets people into, well, why some courts have said we don't care. Because including but not limited to is what I think of as robo-drafting. It's when someone says, I'm going to do a shift and replace every including with including but not limited to. Or I'm going to have a general interpretation provision that says every including means including but not limited to. In other words, we're going to apply this meaning to every example of including in this contract without looking at the context. And courts are entitled to say, you know what, we don't care about your robo-drafting. We are going to look at the context. That's why I can cite cases that have said, including but not limited to, we don't care, including is limited in these examples. So, last week, my latest article came out with a judge from the Delaware Court of Chancery. You're going to say, Adams has a thing about Delaware. It's one of the biggest courts. And here's I'll tell you a little secret about co-writing an article with a big judge. Since we're in Saudi Arabia, you won't tell anyone in the U.S. The secret is you write 99% of the article, and the judge writes 1% of the article, and the judge's name goes first. There, that's. But no, but it's. I'm sort of joking, but that article includes the latest on including. If you like including, check out that article. It's in a blog post. If you want to include, let me put the phone out there. If you want to include examples, if you say we really have to mention oranges, lemons, and grapefruit because they're 95% of our fruit inventory, I say okay, we'll put the examples first and then the general class later, because saying something like this does a better job than including but not limited to as a way of saying those examples, they're not the whole story. So, all right, that's another invitation to you to not use including but not limited to, and to instead take a closer look at how you use including. Because it's just including but not limited to is just one of those phrases that you say, why are we saying this all the time? And it's not necessary. Are we good? Okay.